Hello and welcome back to Texas Real Estate Insights. My name is Michael Berger with Cooper Sotheby's International Realty in San Antonio. Today I thought we'd play a little game of fact or fiction. So let's go ahead and start with the first one. Let's see. A new survey is always required whenever a property sells in the state of Texas. Fact or fiction? That is, in fact, fiction. An existing survey of a property, when a buyer and seller agree to a relationship, the existing survey can be reused. There's a couple of things that go along with that. First off, the seller has to provide a copy of the existing survey. They have to provide a T47 which can either be a T47 affidavit or a T47 declaration. A T47 affidavit is a document that the sellers sign, and it is notarized by a notary, talking about whether or not there are or have not been any changes to the footprint of the property as it is described in the survey that they provide. So let's pretend a seller buys a property, they have it for a few years, they pull out their old survey, and they say, hey, let's go ahead and use this existing survey, Mr. Buyer of my property. And the buyer says, okay, that's fine. Well, they have to sign the affidavit that says this is a true and accurate rendition of the property as it sits. Or they can say this is a true and accurate rendition of the property with the following changes. And the changes could be as simple as we put a shed in the back right corner, things like that, or they made substantial changes to the property. The title company and the lender will require the time period to review that survey and the T47, again, whether it's an affidavit or a declaration, and they can decide if they want to consider that existing survey a good survey and say, yeah, let's go ahead and use it. Or they can say, no, that is not an acceptable survey. A couple of reasons why a survey would be unacceptable would be if the survey is not complete. It might be a full scale of the footprint of the property on the lot that it sits, but it may not have the surveyor's seal, may not have the surveyor's signature, may be illegible, things like that. So the survey, the T47 goes to the title company disperses it to the lender and to their underwriting department. Their attorneys, everybody's attorneys reviews the T47 and the survey, and they make a decision as to whether or not that survey is an acceptable one or if a new one will need to be done. A new one will need to be done if either of the two parties reject it, and from there it is negotiated at the offset of the contract as to who pays for the new survey. Sorry about the glare. Okay, so I've talked about all that. Let's talk about what a declaration is, a T47 declaration. A T47 is basically the same thing or the same vehicle as a T47 affidavit. However, it has more personal information such as date of birth, maybe a driver's license number of the sellers, and then they sign it as a declaration that is a true and accurate rendition of the property, and not an affidavit that is a true and accurate rendition of the property. Subtle difference there, but the difference is the affidavit, T47 affidavit, has to be notarized, and the T47 declaration does not have to be notarized. Okay, next one is, let's see. Wrong direction. Okay, all real estate contracts in Texas must be in writing. Fact or fiction? That is, in fact, a fact. You cannot have in Texas handshake deals. You can, but they're not enforceable. And I guess that's what it boils down to. All agreements between the parties, buyer and seller, have to be in writing. They have to be laid out with all the details and nuances of any contract. If you're buying a property and you want them to include the bar stools that are sitting at the breakfast bar in the kitchen, that requires a non-realty items addendum. Everything has to be laid out in the original agreement that is agreed to between the buyer and the seller. And that just prevents confusion, arguments, situations of mistrust. So it is always required that a contract in Texas has to be in writing. And I'm going to qualify that to say to be enforceable. Everything is in the contract, including broker's representation and broker's fees. Okay, so let's take a look at the next one. I'll try and just bring it up cleanly. Texas requires sellers to disclose all known material defects about a property. And the answer to that is yes. In Texas, there are two versions of the seller's disclosure. One is provided by the National Association of Realtors, or Texas Association of Realtors. The TAR, seller's disclosure, is a 7 to 9 page document. And I say 7 to 9 pages because though it's a promulgated form that's laid out with specific questions, if you use certain programs, it can spill over to 8, 9 pages. I believe it's a 7-page document. But the more information a seller puts in, it could elongate and make it longer to spill onto additional pages. The information that is required to be disclosed is regulated by the state of Texas. Texas Real Estate Commission has laid out what information is considered pertinent for a seller to disclose to a buyer. Does it have aluminum wiring? Does it have this? Does it have that? The seller has to disclose defects about the property. And the Texas Real Estate Commission offers a seller's disclosure, and that version of the seller's disclosure is the minimum amount of information that is required. The TAR, the Texas Association of Realtors form, is expanded and has a lot more questions about the condition of the property, where the Texas Real Estate Commission form is the bare nitty-gritty as to what is required to be disclosed. Buyers are required to receive a copy of that. They are encouraged. I don't think there's a requirement by law that they have to sign off on the disclosure. The disclosure is required to be provided, but it is not required to be returned. There's rules and then there's customs. It's customary to return it, but it is not a rule, because in the contract, as I mentioned a little bit ago, there are sections for everything. All details are laid out, and one of the paragraphs specifically says, has the buyer received it, yes or no? If they have not received it, how many days do the seller's agent have to provide a copy of the disclosure? And then the third choice in that paragraph is the property is exempt from seller's disclosure. There are some situations where a seller does not have to disclose the condition of the property, hence complete a seller's disclosure. And those are bank foreclosures, if the property is an estate, if a spouse is selling property to another spouse from husband to wife or wife to husband, there's not a disclosure needed there. So there's a couple of reasons why a seller would not have a disclosure, but most of the time there will be a seller's disclosure. It is required that a seller provide a copy of that disclosure to the buyer. It is not required a buyer return it, but they have to acknowledge in the contract that they have in fact received it, or the listing agent has to be able to prove that it was provided within the number of days that it was sent to the buyer or the buyer's agent. Okay, next, fact or fiction. The seller always pays for the title policy in Texas, title insurance. That is not a fact. That is fiction. Most of the time, I mentioned it just a minute ago, there are rules and then there are customs. It is customary for a seller to provide and pay for title insurance on a property that they are selling. Because the seller is offering it, and because most of the time the seller gets to pick the title company, they end up paying for it. So it's a custom. It's not a rule, but most of the time people understand when they go to sell a property as a seller, they're going to end up paying for title policy. The title policy is a vehicle, it's an insurance policy that hence it's regulated by the Texas Insurance Commission. And it's an insurance policy that gives buyers what's called peaceful enjoyment to the property. Now, we don't know who owned the dirt that the house sits on back in 1842. And so the insurance that the title company provides, the title policy, gives buyers what's called peaceful enjoyment to the property. So when they insure the property, if anybody pops out of the woodwork and they say, my great, 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 great grandpappy owned this land in 1846, hence I'm entitled to ownership of the property, the title company will step in and basically pay them off, pay them the value that they feel they're entitled to. It's handled by the insurance company to allow the buyer to retain and enjoy the property that they bought and were covered by the insurance from the Texas insurance, Texas title policy. Okay, are there times that the buyers pay for it? Absolutely. Sometimes in an incredibly competitive market like during and right in the midst of COVID, it was not uncommon to have 10, 12 offers in the first 48 hours of a listing hitting the market. And so when we wrote offers for buyers that were very intentional about trying to secure a property during that incredibly busy time, it wasn't unusual for us as buyers agents to suggest that the buyer pay for the title policy. If the buyer pays for the title policy, then they generally have a right to pick the title insurance they want to use. If the seller pays for the title policy, the seller generally has the right to pick. Hold on, a swig of water. Okay, so I hope that is clear about the seller. It is fiction that the seller always pays for the title insurance in the state of Texas. Next, fact or fiction. You must put 20% down to buy a home in Texas. That is fiction. It is pretty normal for a buyer to put 20% down. I encourage buyers to put 20% down. If you put 20% down, you fall under 2 or 3 things. One, most of the time that's going to go as a conventional loan. Second, you're going to avoid any private mortgage insurance or insurance that the lender is going to require if you were to put 5%, 10%, 15% down. There's an insurance policy that the lenders take out that will gap. It's basically gap insurance that will protect the lender if they have to foreclose on the property because of non-payment and somebody only put 5% down. There's also government backed. It's not government loans, but government secure types of loans such as VA, where the veteran can put 0% down. There's FHA, where a buyer who is utilizing FHA, an FHA loan program, they're putting 3.5% down. It used to be 3%, but those days are long gone. It's now the buyer has to put 3.5% down. There are some hybrid loans that lenders use, such as a doctor's loan. A doctor just graduated. He has all of the student loan debt. Doctors that are in the market to buy a property sometimes can get a 0% down. Lenders are not adverse to working with buyers who are not putting 20% down, but may be putting 5, 10, 15% down. They're not adverse to that, but any buyer who is putting less than 20% down should be aware and comfortable with that they're going to be paying the private mortgage insurance or mortgage insurance protection. It depends on the type of loan as to what it's actually called, PMI or MIP. But either way, there's going to be a level of gap insurance for whatever the percent down all the way through to equal 20% that protects the lender. And that's not a bad deal, because if you think about it, the lender working with somebody who's putting 10% down as opposed to putting 20% down, they are actually taking on a slightly higher risk. So they should find a way to be insured against loss due to that increased risk. And that risk, that vehicle that they use to protect themselves is the private insurance, that gap insurance that I've mentioned. And that will allow people who are not flush with cash with the 20% to put down to be able to still experience homeownership. Okay, next factor, fiction. You can buy and sell real estate in the state of Texas without a license. Fact or fiction? That is a fact. If you are self-representing, you can either sell a property on your own without a licensed real estate agent assisting you, or you can buy a property without a licensed real estate agent representing you. We've all heard of FSBO, for sale by owner. The only thing you cannot do if you are not licensed in the state of Texas is represent other people. So John Doe, who is not a licensed agent, cannot represent his cousin, Jane Doe, in selling her house. Jane would have to self-represent, or Jane would have to hire a licensed real estate agent to represent her in the sale of her property. But unlicensed people cannot represent other individuals in the sale of their property, and that includes attorneys. Attorneys cannot represent buyers and sellers in a real estate transaction unless they are also licensed real estate agents. So, sorry about that, attorneys. Next, let's see. Next to the last, we're going to do 8 of these. I thought 8 was a nice round number. So number 8, earnest money must be paid by a personal check. That is in fact fiction. The reason it's fiction is because the title company doesn't want to receive earnest money in cash. That is highly discouraged, and I don't think it's even acceptable form anymore. However, they still accept personal checks. They accept money orders. The title company really wants just to use wires. They will provide wire instructions for the buyer to be able to wire the earnest money and the option fee in one fell swoop to the title company through the wire instructions that the title company provides. They are not excited about receiving a personal check. They are not excited about receiving a cashier's check. Their goal is to try and streamline everything the best they can and break it down to a simple wire. And a wire is not difficult, so I don't think buyers should have an issue with that. But the buyers are now being discouraged from providing personal checks for almost anything having to do with the real estate transaction. Okay, let's move on to the last one. Trick question. A buyer and the buyer's agent sat down. They drew up an offer. They have sent it to the listing agent. The listing agent takes that, prints it, and goes and meets with the seller. They sit down. The seller signs the documents. The listing agent executes the contract. Once the seller signs an offer, it is a binding contract. Fact or fiction? Told you it's a trick question. It is in fact fiction. The seller signing the offer and executing it as a contract does not make it a binding contract. It is a contract in theory, but communication from the listing agent back to the buyer's agent is what triggers the binding effect. So the listing agent can't go get it signed on a Thursday night and then go home, have dinner with the family, go to the lake on Friday, come back on Sunday, and then send it over to the buyer's agent and say, yeah, we've been executed for 3 days. That is not how a contract works. Part of the nuances of the existence of a contract is communication back to the offering party that the contract has been signed, it has been executed, and conveyance of that contract from one party back to the other is what establishes the binding agreement. So that was fun. Let's get into my quick disclosures. I am not an attorney. I do not practice law. I am a licensed real estate broker in the state of Texas. However, I am not your broker. If you have a licensed agent representing you, good for you. Gina, my wife, Gina Candelario, and I have a network throughout the state of Texas of professionals that we work with. And if you are considering buying or selling in the state of Texas, reach out to me either in the comments. My email is in the description of this video. Send me some information. I'll reach back out to you with some questions, but we can put you in touch with real estate professionals who specialize in the area where you're either thinking about buying or selling. We had a client reach out to me, I think Thursday. Today is now Monday. No, it's Tuesday. Let's get this right. Today is Tuesday, October 7th. Last Thursday, I had a client reach out and they said, do you and Gina work in the Canyon Lake area? We do not. Texas Real Estate Commission requires as part of our licensing that we are competent. Competency is one of the requirements for us to practice real estate. We are competent in San Antonio. We are competent in Berger County, and hence we are not practitioners of real estate in Amarillo or Dallas or Frisco, Texas. We are not operating in areas of the state that we are not considered competent. So we said we are not practitioners of real estate in Canyon Lake, but we have relationships with an agent out there. So I did share that information with her. She is a seller of a lot in Canyon Lake, and she lives in Houston. So we're pretty excited to build that relationship. So again, if you have any real estate needs throughout the state of Texas, we are not going to represent you unless it is here in San Antonio, but we have relationships through the Sotheby's network with agents throughout the entire state. So send me an email, send me some questions, even if you're not interested in participating in the real estate market today, this week, next month, but you have you have questions about real estate. I am here to be of service. Again, my name is Michael Berger with Texas Real Estate Insights, and I am a real estate broker of 25 years, and I am affiliated with Cooper Sotheby's International Realty here in San Antonio. Let me see. The market is picking up. Things have been incredibly soft. I think that's a good way to say that. The real estate market has been incredibly soft throughout the state of Texas for probably about 4.5, 5 months. There's quite the strong pent-up demand, but I don't think anything's going to cut loose. There's too much of a level of uncertainty. Some economists are saying it's going to start picking up in April. I think it might be a little bit before that. I think people are buttoning down. They're going to get through Thanksgiving. They're going to get through Christmas. They're going to wake up in January, maybe February, and say, okay, I think it's about time to pull the trigger, whether it's putting their house on the market or a buyer saying it's time to secure a property. Things are going to continue to be soft. They're going to be a little slow, but everything goes in waves, ups and downs. I remember 08, 09, They were terrible years, but we were fortunate that we were still did business. We survived. In 10, 11, they were very tasty years. The real estate market was really kind of slow in 17, 18. There was uncertainty. There was mistrust in the market. And then COVID hit in 19, 20, 21. They were very tasty years as well. We're in a slow time, but that's okay. These things have to come. It slows down the building process. It brings pricing back under control. I feel like there's a very, very, very good opportunity early part of next year for the real estate market to take off, but I have no crystal ball. Reach out to me, like, subscribe, do all that stuff, and I hope you have a great day.